Hello, everyone, and welcome. My name is Lauren Giles. I'm the president of the Women Law Students Association. The purpose of our organization is to prepare women law students for future careers in the legal field. I want to thank you all for coming and for your support, and to introduce our first vice president, Danielle Leslie.
Hello, my name is Danielle Leslie, and it has been my pleasure to serve as this year's chair of the Edith House Lecture Committee. I'd like to join Lauren in welcoming you to the 26th Annual Edith House Lecture. Edith House would certainly be humbled by the fact that there is even a 26th lecture, as she was surely humbled by the first. In a letter dated November 14, 1982, Ms. House wrote to Wilson members that she was flattered and somewhat awed at the prospect of a lecture series being established in her honor. Ms. House approached the lecture as she did the life and the law. It was simply something that she did, something that she was, and it garnered no special accolades, or in her own words, no special trouble. She did not consider herself the trailblazer that we honor today, but she was indeed a trailblazer. Edith House was born and raised in Winder, Georgia. Edith made up her mind at the age of 13 that she would become a lawyer, after her father informed her that the Georgia legislature had passed a bill allowing women to practice law. I remember saying, "That's what I'll be," not knowing a darn thing about it. Shortly, it was all over town that Edith would be a lawyer. That teenager's vision became a reality when Ms. House entered the University of Georgia Law School in 1922, only one of two women in the class. 3 years later, in 1925, Ms. House graduated co-valedictorian of the first law class to graduate women. She found it shameful that she had 3 job offers and had to turn 2 of them down. She accepted a job in private practice in Florida before becoming Assistant U.S. Attorney General 4 years later. Over the next 34 years, she was dedicated to her life and the law and worked to reorganize the Southern District of Florida before retiring in 1963. Despite achieving what many women in her generation did not and probably could not have dreamed of doing, Ms. House did not let the magnitude of her accomplishments affect her. In fact, in responding to what she thought of Wilson's commission of her painting, Ms. House said, "I knew I was going to have to make a living doing something, and school teaching didn't appeal to me. I never have figured I accomplished anything extraordinary except I stayed off welfare and I stayed out of jail. Just the fact that I was a woman and practiced law at the time made a big splash, but I don't see why everyone should get so excited about that." We are lucky that Ms. House allowed us to get excited and honor her as an example of great achievement for women in the law. Since 1983, we have invited outstanding female attorneys to speak to us about a variety of topics in the law. The success and long life of this lecture is sustained by the generous contributions to the Edith House Lecture Fund and the continued support of the University of Georgia School of Law's administration, faculty, and staff. For this support, the Women's Law Student Association is incredibly grateful. At this time, I would like to introduce J. Alton Hosch, Professor of Law and Dean of the Law School, Rebecca White. Dean White specializes in the areas of labor law, employment discrimination, employment law, and labor arbitration. Dean White has received many honors, including the Josiah Miggs Award, UGA's highest honor for teaching excellence. She is a 6-time recipient of the Faculty Book Award for Excellence in Teaching and has also received the John C. O'Byrne Award for contributions furthering student-faculty relations. She served as a UGA Senior Teaching Fellow and was inducted into UGA's Elite New Teaching Academy. Dean White earned her undergraduate degree from Eastern Kentucky University and graduated first in her class from the University of Kentucky College of Law. She has served as Judicial Law Clerk to Chief Judge George C. Edwards of the U.S. Court of Appeals for the Sixth Circuit before entering private practice and eventually joining the UGA School of Law faculty. In October 2004, she was named Dean of the Law School. Dean White is an avid supporter of student groups, and WILSA, along with the Edith House Committee, sincerely appreciates her for being here today. Please make welcome Dean White.
Well, thank you, Danielle, for that introduction. It is truly an honor to introduce today's Edith House lecturer, the Honorable Shirley Huffstetler. Judge Huffstetler is someone that I first learned about when I was a law student and is someone whose career I have long admired. Imagine my delight and surprise to find myself at her lunch table last year at the Carter Conference and to finally get to meet her. And Judge Huffstetler, thank you so much for coming back to Athens. The word trailblazer, as Danielle says, does get used a lot, particularly when applied to women in the legal profession. And Shirley Huffstetler is the real deal. She graduated from Stanford's law school at a time when precious few women went to law school. And although she served as articles editor and book editor of the Stanford Law Review, the only legal employment she was offered, unlike Edith House, was as a legal secretary at a probate law firm. She said no thanks to that and started her own law practice. Judge Huffstetler has gone on to have not only a distinguished career, but an extraordinary one. In 1960, she served as special legal consultant to the Attorney General of California, consulting on the Colorado River litigation that was before the United States Supreme Court. In 1961, she was appointed judge of the Los Angeles County Superior Court, and her appointment brought the membership of that court to 1 woman and 119 men. In 1966, she was appointed Associate Justice of the California Court of Appeals, and in 1968, Judge Huffstetler was appointed by President Lyndon Johnson to the U.S. Court of Appeals for the Ninth Circuit. At the time of her appointment, and for many of her years of service on that court, she was the only female federal appellate judge in the United States. In 1979, Judge Huffstetler became the first Secretary of the U.S. Department of Education, appointed by President Jimmy Carter. And at the Carter Conference, President Carter said that had he had the opportunity to make an appointment to the United States Supreme Court, Judge Huffstetler would have been his nominee. In 1981, Judge Huffstetler returned to private life and to law practice. She is one of the country's leading experts in appellate litigation, and she is senior of counsel to the law firm of Morrison and Forrester. Judge Huffstetler has held an endowed chair at Stanford's Law School as a visiting scholar, has been awarded 20 honorary doctorate degrees and a slew of numerous honors and awards, including the American Bar Association's medal, which is the highest recognition our ABA bestows on anyone. Judge Huffstetler has been quoted as saying, "Security is not the meaning of my life. Great opportunities are worth the risks." She has taken risks. She has been given great opportunities, and she has made the most of and has reveled in them. Please join me in welcoming Judge Huffstetler.
Thank you very much for a very generous introduction, which is undeserved but appreciated. I want to talk to you about some things that I hope will interest you about the administration of justice in the United States. All of us have heard the expression, war on terrorism. We've heard it so much and read it so much we barely think about what in the world it means. Wars are declared on hostile countries. They're certainly not declared on ideas. What we have to recognize is that the expression is a figure of speech. Many of you here may recall that other presidents of the United States have declared wars on situations which made the country very uncomfortable, such as the war on poverty and the war on drugs. Now, how in the world you make a war on poverty is beyond me. The use of that expression, however, evokes questions about the emergency powers of the United States president in times of war or in times of other sorts of emergencies. The questions about the limitations, if any, on the power of President and Congress in times of emergency has been before the United States Supreme Court a number of times over a period of many years. But I have to say that the decisions cannot be reconciled with each other, and very few provide any helpful guidelines on the situation that confronts the United States today. I'm going to talk about a number of those cases, but I shan't bore you with the citations. I will send to the law school a whole list of citations in case any of you wish to read the opinions yourself. It's too bad that the court has not reached a consensus on some of the major issues confronting the nation in presidential powers in times of emergency. But it's very rarely that the court has come to any conclusion that really works for more than one case at a time. A few decisions have explicitly limited the president's emergency powers, but that's when the Constitution itself is spoken. For example, in 1972, in a case concerning the United States District for the Eastern District of Michigan, the question was whether the president, acting through the Attorney General, had the power to approve for wiretaps to gather intelligence information. Doesn't that sound familiar? Because it is. And then the question is whether or not warrantless electronic surveillance was appropriate in the United States. The court recognized that, of course, questions of this sort are of national concern because it requires sensitivity to both the government's right to protect itself and the person's right to be secure in his or her privacy against unreasonable government intrusion. This particular case began as a criminal proceeding in Michigan in which the United States charged 3 defendants with conspiracy to destroy government property. The defendants moved to compel the United States to disclose electronic surveillance information and to conduct a hearing to decide whether or not the information tainted the evidence upon which the indictment was based. The response was that the Attorney General had approved the wiretaps to gather intelligence necessary to protect the nation from attempted on domestic organizations from attacking the United States. The surveillance logs were sealed in the district court. That court held that the surveillance violated the Fourth Amendment and ordered the government to make full disclosure to the defendants of the wiretap conversations. Does that sound familiar? It should. The Court of Appeal affirmed and the Supreme Court granted certiorari. The Supreme Court recognized that federal statute gave broad authority to the president to take measures to protect the country against actual or potential attack and to obtain foreign intelligence information. The statute said nothing about foreclosing the president from protecting the country from overthrow of the government by force and violence. The Supreme Court agreed unanimously with the lower court that the Fourth Amendment foreclosed the surveillance information that had been the basis of the prosecution. I remind you of a quotation from Chief Justice Earl Warren because I think it's a very valuable one to keep in mind. What he explained in the case called United States against Roble was this: this concept of national defense cannot be deemed an end in itself, justifying any power designed to remove such a goal. Implicit in the term national defense is the notion of defending those ideas and values which set this nation apart. It would be indeed ironic if in the name of national defense, we would sanction the subversion of those liberties which make the defense of the nation worthwhile. Amen. Several presidents of the United States have assumed extraordinary power during national crises, and no president of the United States ever assumed the emergency powers as did Abraham Lincoln at the time of the war between the states. And although most of the law of the United States remained constant during the Lincoln administration, major adjustments were required during the course of the war that was implemented by President Lincoln. Indeed, the extraordinary powers that the president assumed during that period of time have never been duplicated precisely. He assumed unprecedented authority on his own initiative, supported by the then majority of public opinion. He briefly suspended the writ of habeas corpus. The so-called Lincoln dictatorship lasted for a period of 11 extraordinary weeks. Many of those decisions today are understandably deemed very questionable under our constitutional form of government. He did all of those things in order to preserve the Union. At that time, Congress ratified the extraordinary acts he undertook because the president asked Congress to do so. He was not the only president to exercise emergency powers. President Woodrow Wilson exercised a lot of emergency powers during the First World War. He did so, however, almost entirely with the authority delegated to him by Congress. Among the statutory delegations to Wilson empowered him to take over and operate the railroads, the water systems, to regulate and commandeer all shipping facilities in the United States, to regulate and prohibit exports, to raise an army by conscription, to allocate priorities in transportations, as well as to regulate the conduct of resident aliens, and to operate all of the telephone and telegraph systems, which is not exactly a bunch of trivial powers. Woodrow Wilson, through his terms as president, considered him sort of a prime minister with respect to Congress, but he got his way. The constitutional barriers for presidents weakened considerably during the Great Depression when Franklin Roosevelt was president. He exerted a lot of emergency powers. He arrogated himself the powers of this emergency of the Depression almost as much as Presidents Lincoln and Wilson had before him. Using his crisis authority, President Roosevelt declared a financial state of siege, empowering him to take extraordinary action. Like President Lincoln, however, President Roosevelt succeeded in persuading Congress to approve what he had undertaken. He proposed to Congress a complete and detailed program of emergency legislation. He unquestionably had remarkable success in obtaining approval by acts of Congress. The dozen or so important statutes enacted by Congress in special session then constituted the largest single instance of delegated power in American history. During the Great Depression, Roosevelt did an extraordinary number of things. The Supreme Court went along until it came to some of his favorite New Deal legislation, which a majority of the court, which at that time was very conservative, rejected as unconstitutional. His authority in crisis was expanded during the Second World War. He gave extraordinary power that he believed was necessary to wage total war. Although the country had extraordinary success in production, research, and supply during the Second World War, we have to remember that there was a very deep black mark made in the record of American history by sending 70,000 loyal American citizens of Japanese descent into concentration camps. And a very black mark against the Supreme Court of the United States was to permit that travesty to be upheld in a case which you may recall as the Korematsu against the United States. The sources of President Roosevelt's emergency authority during the Second World War and the Great Depression was the president's own broad reading of his constitutional power, but that power would not have been useful if Congress had not approved it. Congress did so. It's genuinely surprising that during all of that crisis government, that most of the political freedoms of the Americans were never touched. Freedoms of speech, assembly, and the press were not bothered at all. But the president's execution of extraordinary power during times of emergency has not always been adequate to approve the exertion of such powers. Harry Truman found this out when during his presidency in the war was proceeding in Korea, he sought to take possession of and control the world's steel mills in order to prevent an impending strike. The owners were infuriated, and the federal courts were asked to declare the orders of the president invalid and to issue a permanent injunction restraining enforcement. The lower federal court issued an injunction restraining the secretary from continuing the seizure and possession of steel mills, and the Supreme Court promptly granted certiorari. The Supreme Court observed that the presidential power to issue the order in question had to either come from an act of Congress or from the Constitution itself. A very famous decision of the Supreme Court in that case was Youngstown Company versus Sawyer, which the Supreme Court decided in 1952. Because no statute authorized the president to take possession of the mills, the next question was whether Congress could have given him such power. The court decided that Congress had not done so, and that the president's role as commander-in-chief of the armed forces during a war did not give him power to take possession of private property to prevent a labor dispute from stopping production. The court held that that job was for the nation's lawmakers and not for the military authorities, or indeed for the President of the United States. The court leaned heavily on the explicit power of Congress to authorize the taking of private property for public use, of course always with the proviso that just compensation shall be paid. The case was easier for the court because Congress had specifically denied such presidential powers under 1947 legislation. Justice Jackson's criticism of the president was particularly pointed when he observed, and I quote, "No doctrine of this court could promulgate which had more sinister and alarming than a president whose conduct of foreign affairs is largely uncontrolled and often is unknown, can vastly enlarge his mastery over the internal affairs of the country by his own commitment of the nation's armed forces to some foreign venture." He was firm that no president could invest himself with undefined emergency powers. What he said was emergency powers are consistent with free government only when their control is lodged elsewhere than in the executive who exercises them. The opinion was not unanimous that the Chief Justice dissented. The argument is still raging about whether courts have a role to prevent the president from infringing upon the powers of Congress and the judiciary. Under one school of thought, that issue should be non-justiciable because of the political question doctrine or the standing doctrines. An example of that debate is Goldwater against Carter, in which a plurality of the court held that the case presented a non-justiciable political dispute. Most of the cases challenging the constitutionality of the Vietnam War have been dismissed on political question grounds. The political question analysis means that the court has a basis for refusing to consider challenges to executive power, which means effectively a vote in favor of very broad inherent presidential authority. The use of that doctrine increases immensely the unreviewable power of the presidency. The question could be resolved by asking the question whether the act is discretionary or not. The question of whether an official is exercising lawful discretion is not always a political question, as the court decided in Baker against Carr in 1962. The question of whether one branch of government has exceeded whatever it has committed to itself is a question of constitutional interpretation, which it is the responsibility of the United States Supreme Court to decide. As properly understood, the political question doctrine could be used simply to preclude review of the exercise of discretionary power. However, it should not prevent a court from determining whether the executive's conduct is an unconstitutional use of presidential and legislative power. It is quite inappropriate as a matter of constitutional interpretation to require courts to abstain from deciding all challenges to executive power until Congress acts. The courts are required to decide whether the president's conduct is lawful. It should not duck that responsibility by calling the issue a political question. A second basis upon which to avoid the issue of presidential power by the judiciary is the principle of standing. That one, principle of standing is well known to most everybody in the law school. The principle is based upon the constitutional restriction of the jurisdiction of federal courts to cases and controversies. The purpose of standing is to ensure that the parties who are presenting issues to the court are properly interested. It would be extremely helpful in avoiding standing difficulties if members of Congress themselves specifically granted standing. A suggested approach in deciding whether the president has overstepped his power is a consideration of three factors. And here I quote, whether the president is exercising a power constitutionally committed to another branch of government, whether the effect of the executive conduct is to prevent performance of legislative or judicial tasks, and whether the effect of the president's action is to prevent adequate review or control by another branch of government. That doesn't really solve everything, but it gives you a good handle to begin in. Deeply troublesome constitutional questions now arise from the imprisonment of hundreds of men in the facilities in Guantanamo. Most Americans probably think that the persons who are confined in Guantanamo are terrorists. From the evidence that has emerged during the last several years, however, we know that a large number of those prisoners have nothing to do with Al-Qaeda or the Taliban in Afghanistan. A very large number of them were captured by bounty hunters when they were found in Afghanistan. Those bounty hunters captured those persons and handed them over to military authorities in Afghanistan to receive monetary rewards. The legality of the incarceration of those persons have been brought to the attention of the United States Supreme Court several times. One of the earliest cases to reach the court is Rasul against Bush, which was decided in 2004. The petitioners in that case were 2 Australians and 12 Kuwaitis who were captured during the hostilities in Afghanistan and who are being currently held in Guantanamo Bay. Those petitioners filed habeas corpus petitions in the District of Columbia courts challenging the legality of their detention. All of them alleged that none of them had been a combatant of the United States or engaged in any terrorist activity, and none had been charged with any wrongdoing, permitted to consult with counsel, or provided access to the courts or any other tribunal. Each of them claimed denial of their rights, violated the Constitution, violated international law and treaties of the United States. Construing all the actions as petitions for writs of habeas corpus, the District of Columbia dismissed them for lack of jurisdiction, relying on a quite inappropriate decision of the Supreme Court. The Court of Appeals in the District of Columbia affirmed, and the Supreme Court granted certiorari. After observing that the writ of habeas corpus had been developed to challenge executive imprisonment, the court stated that it recognized the federal court's power to review the application for habeas corpus in many cases involving executive detention in wars and time of peace. The Supreme Court observed that the petitioners in this case were not nationals of countries at war with the United States, and they have averred that they had not engaged in any aggression against the United States. The Supreme Court held that the habeas statute applied to prisoners held at Guantanamo. The Supreme Court held that the federal court had jurisdiction to determine the legality of the executive's potentially indefinite detention of individuals who claimed to be innocent of any wrongdoing. The Supreme Court remanded the case to the District of Columbia Court. The decision was not unanimous. Justices Scalia, Rehnquist, and Thomas dissented. Not a rare split in the court, I might add. Among the festering constitutional questions today is whether other prisoners of Guantanamo contain writs of habeas corpus challenging their confinement. For years, when these men have not had access to counsel, they have not had access to federal trial courts or to any other remedy that can successfully challenge their confinement. Everyone here recalls that after the 9/11 attack, Congress repeatedly approved the expansion of presidential powers. It authorized the invasion of Afghanistan to make war on al-Qaeda and the Taliban. Congress also approved the president's request to establish military tribunals to try people who are detained at Guantanamo with the enactment of the Detainee Treatment Act of 2005, which also deprived any court, justice, or judge of jurisdiction to consider a habeas corpus application on behalf of any of the prisoners at Guantanamo Bay. Under the rule of the DTA, the military commissions were empowered to exclude from the accused and the accused civil counsel any part of the proceeding that the officials decided was a basis upon which to close the proceedings. Most of those proceedings have been accordingly closed. The DTA rules also permitted the introduction of any evidence, including hearsay, and evidence obtained through coercion, that in the opinion of the Commission's presiding officer would have probative value to a reasonable person. I ask you to think hard about what that means. At that time, the United States Code of Military Justice conditioned the President's use of military commissions on compliance with American common law of war and with the terms of the four Geneva Conventions. But Congress reduced the ability of anybody in Guantanamo to rely upon the Geneva Conventions. The DTA deprived any court or judge of any court to consider a habeas corpus petition filed by any Guantanamo Bay detainee, and only invested the District of Columbia Circuit with jurisdiction to consider the matter of appeals. But of course, that's not adequate because there was no trial record of the sort that the court can reasonably evaluate. In 2006, the Supreme Court once again had before it another writ of certiorari challenging the petitioner's detention at Guantanamo. The DTA was silent about whether the provisions destroying habeas corpus opportunity to anybody was going to be extant. But the court, in a divided decision, decided that although the current statute deprived the federal courts of any habeas jurisdiction, it did not apply to those petitions for habeas corpus which were pending at the time the act was enacted. And the District of Columbia Court held that the writ would be granted because the DTA had no power to convict based on evidence that the accused would never see or hear because, as many of you may know, the proceedings before the military tribunals do not permit the person who's accused to be present at the trial. A very sharply divided Supreme Court granted the writ. The majority held that the DTA lacked power to proceed because the structure and procedures violated the Uniform Code of Military Justice in the 4 Geneva Conventions. The Supreme Court was heavily persuaded by the fact that Hamdan had already been excluded from his own trial. Shortly thereafter, the Bush administration began working with Congress to enact legislation authorizing the use of more powerful military commissions. The new commission, which is called the Combat Status Review Tribunal, established the authority of the President and the Secretary of Defense. This allowed reliance on the Geneva Conventions and this allowed any prisoner having access to a writ of habeas corpus. One of the constitutional issues is the provision of Article 1, Section 9, providing that the privilege of habeas corpus of the Constitution shall not be suspended unless when in cause of the rebellion or invasion of public safety may require it. Apparently that provision has not been meaningful to the current military commissions because the detainees are not provided with the assistance of personally selected counsel and they're only provided by military counsel who does not act as a legal counsel, and also they are supplied with an interpreter. The tribunal is expressly given the right to consider any information it deems relevant and helpful to the resolution of the issues before it, which is virtually no holds barred. I am one of 10 former federal judges, both trial and appellate, who have filed an amicus brief with the United States Supreme Court, arguing that the review permitted by the current Detainee Treatment Act is an inadequate substitute for habeas corpus because the court is not authorized to determine the extent to which the CSRT has been relying on statements obtained by torture and other impermissible coercion. That is still the fact. The Supreme Court hasn't decided that case yet, but I still have some faint hope that they may do so. After all, reliance on evidence obtained by torture has been abandoned, at least in England, by 1215. Common law courts did not admit statements extracted by torture or other inhumane treatment to support a determination of guilt because such statements are inherently unreliable and because taking evidence obtained by cruelty corrupts the judicial system, as I think all of us will agree. The Fifth Amendment of the United States Constitution is an illustration of the founders' response to torture and other means of obtaining confessions. The Eighth Amendment's foreclosure of cruel and unusual punishment is also an admonition to all departments of the United States to warn against such violence against human beings. Many of the procedural safeguards of the United States Constitution have also been efforts to ensure against such ancient evils. Nevertheless, since the implementation of CRST rules, the government has consistently maintained that the CRST can entertain testimony that's been obtained by torture. At the time that the amicus brief was filed in the Supreme Court, the transcripts and documents found that 18% of the Guantanamo detainees alleged torture. The record does not indicate whether the CRST ever resolved the allegations of torture before the prisoners' continued detention. It is widely reported, as many of you know, that interrogators of those prisoners have been tortured by waterboarding. As you know, waterboarding means that the prisoner has his face covered with cloth and is then covered constantly with water in order to simulate drowning. I do not believe that that is an appropriate means to gather evidence against anybody in the United States. No matter how the current Supreme Court will deal with the pending petitions of hearing, it is vitally important that persons who care about the administration of justice should let their representatives in Congress know that they deeply disapprove of the persons who are confined in Guantanamo, and also disapprove of the removal of jurisdiction to entertain petitions for writs of habeas corpus. One of my law partners represents a client confined at Guantanamo. He has described to me the conditions of confinement of that client. The man is a citizen of Saudi Arabia who was captured in Afghanistan. At Guantanamo, he is being held in solitary confinement in a jail cell with no windows. He is permitted outside to exercise 2 hours a day in a penned enclosure. Private lawyers are not permitted to bring in any interpreters in the institution. The only way that my partner could communicate with his client is to use an interpreter supplied by the military. It's extremely difficult under such circumstances to obtain any information which are very helpful to the client. I just believe that it's important for all of us here in law school to recognize that it's important that the citizens of the United States speak their minds up to the members of Congress about what they think of the United States holding these prisoners for years without any trial in which that person can be present and without any concern about the evidence against them having been elicited by means of torture. It seems to me that it is a severe blot on the history of the United States to have people imprisoned. After all, these people have not been convicted of any crime. It is time for us to speak up as members of the United States ourselves to ask Congress to reconsider this legislation which was passed in a sense of anxiety about the 9/11 attacks. The 9/11 attacks were terrible, but there is no basis on any evidence produced so far that the hundreds of men who have been confined without trial in Guantanamo had anything to do with those attacks, that they had anything to do with Al-Qaeda or with the Taliban, or that they are citizens or even residents of Afghanistan. We don't like to see the nation suffer its reputation of fairness by confining people as if they were livestock. I think we ought to tell our representatives to stop listening all the time to what the Secretary of Defense has to say and listen to what the people of the United States have to say. It is our responsibility, among others, to see that the basics of constitutional law be observed by the United States. That has not been done at the present time, and I urge each of you to give serious thought to how you can tell your representatives and senators that you disagree with the blight that's been put upon the reputation for justice in the United States by the imprisonment of those hundreds of people at Guantanamo. I ask you to think about it hard because it's a very important issue. Thank you very much for your attention.